The transition phase laid down in the withdrawal agreement between the UK and the EU ends on December 31st. There's still great uncertainty as to how the situation will develop afterwards. Even before the transition phase laid down in the withdrawal agreement ended on December 31st, the parties to the agreement had already got into their first dispute. The UK has announced a bill to comply with the 1998 peace agreement for Northern Ireland, the Good Friday Agreement. But it doesn't comply very much with it. It is a problem for it. The European Union sees this as a violation of the regulations on the border between Ireland and Northern Ireland contained in the Withdrawal Agreement. A solution is not yet in sight. Meanwhile, negotiations on a future comprehensive international agreement between the UK and the EU are proceeding very slowly. After the 9th round of negotiations, it no longer really looks as if such an agreement will come about before December 31st. Of course, the situation can change at any time and there's still plenty of scope for politics and diplomacy, but not plenty of time. Nonetheless, companies on both sides of the English Channel now have to deal with very seriously with the possibility of a hard Brexit on December 31st. The transition phase, during which the UK is still, like one for many, but not all, member states of the European Union, was to be dealt with, then expires without a new international agreement in force that reorganizes the relation between the two sides. So far, no one in the UK has really felt any change. The proposal that the European Union has presented for a new international agreement with the UK also includes rules for aviation. I talked about aviation sometimes before, but this is a really good example for all the many topics that are influenced by this people usually don't think about. In Title 12, the draft published by the European Union, in Chapter 1, that provides to regulate air traffic between the UK and the EU in accordance with the traffic laws that have been customary in international air traffic law for decades. While some provisions are designed to provide operational flexibility for airlines, ownership and control of an air carrier should, as usual, depend on nationality. For the airlines in the European Union, access to capital from the UK is made more difficult and vice versa. For trade in aircraft, parts and equipment, Chapter 2 of Title 12 of the draft provides for future relations to be regulated in a very similar way to the agreements already in place with the USA or Canada. In particular, the mutual recognition of licenses for aircraft, parts and equipment, as well as for development, manufacturing and maintenance companies, and for aviation personnel, should be facilitated. The draft provides for some procedural rules and a joint supervisory body in a separate appendix. So far, however, the European Union and the United Kingdom have been unable to agree on many other points on the draft. The proposal submitted by the EU so far only shows what the European Union has in mind for the future. Applicable laws is far from being created. If there is a hard Brexit on December 31st, a situation will rather arise in which for companies in the EU and for companies in the UK, it will be, or you can say it will essentially depend on the law applicable in the respective territory. Both sides of the English Channel then each decide for themselves how they want to deal with the other side and how the lack of an international agreement will affect companies at home. For the aviation industry in their own country, the UK Civil Aviation Authority, the UK CAA, has already announced that there will initially be a period of validity in UK for permits issued before December 31st. Even in the event of a hard Brexit, all type approvals and release certificates for aircraft and parts issued before December 31st remain valid in the United Kingdom. For permits that were issued before December 31st, according to the then applicable Union Aviation Law, the EASA requirements, a 2-year transition period should apply in accordance with the law applicable in the United Kingdom, during which they remain valid as long as they do not have to be renewed beforehand due to a time limit. It remains to be seen whether and how exactly these details of the UK CAA will be legally implemented and in what way this will actually create legal certainty for companies that export their products to the UK or have subsidiaries or branches there. Nonetheless, the political message to the aviation industry should be clear. The UK CAA formulates this on September 23rd, 2020 as follows. Whatever the next round of UK-EU negotiations bring, you can be reassured that the CAA remains committed to making the final stages of the transition period as smooth as possible for consumers and businesses in the aviation and aerospace industries. We will do what we can. Achieving the smoothest transition possible depends on how businesses playing their role. The European Union has so far opted for a significantly different approach. On the continent, it is emphasized that after December 31st, all permits for companies, products and personnel will lose their validity if they were issued to companies or people within the sovereign territory of the UK. For airlines from the UK, this means that they are only allowed to fly into the European Union as a third country airline. In the absence of an agreement on traffic, scheduled air traffic will only be restricted, if at all. The precise position of the EU can be found in the Commission's communication on air transport of March 16th. According to the will of the EU, however, in the event of a hard Brexit, all other permits granted to companies or aviation personnel in the United Kingdom will also lose their validity after December 31st. The European Commission writes in its communication on aviation safety of March 16th, the aircraft engines, propeller types, certificates, parts and equipment approval certificates and design organization approvals and certificates for UK residents will lose their validity in the EU during the transition period. Holders of approvals or certificates issued by the competent authorities of the UK will be informed that these approvals and certificates will be valid in the EU after the transition period no longer. This affects development and manufacturing companies, maintenance organizations, but also pilots, flight instructors, flight attendants and technical staff. However, in its communication of March, the European Commission also makes a decisive point. Stakeholders are reminded that EASA is accepting applications from UK approval holders for certain third country approvals. This concerns the following approvals and certificates, like manufacturing organization approval, individual manufacturing organization approval, approval as maintenance organization, and others. In doing so, the European Union is not creating security of existence and does not shy away from the situation that arises as a result, insofar as this has a negative effect on companies within its own jurisdiction. There will only be a hard Brexit without a break if companies from the UK take advantage of the possibilities of third country approval in good time. The situation around Brexit is political, and how things will develop will be shaped by politics. Describing the legal situation that will apply in the event of a hard Brexit after the end of December is therefore fraught with great uncertainty at this point in time. Reliable statements cannot be made. The only thing that is certain is that the previous aviation law will continue to apply within the European Union unless it is changed within the framework of the procedures to be followed. Companies that work in the EU must therefore carefully examine the possible effects of a hard Brexit on the specific situation in which each individual company finds itself. Are there suppliers from the United Kingdom? Are there any individual registrations, certificates or attestations relating to or issued by a manufacturer or other UK-based company in the aircraft's history files? If so, how can this be dealt with if these documents should lose their validity? Should you also fly to the UK after December 31st? If so, how can this be implemented? Depending on the company's business model and the processes and business transactions involved, the effects of a hard Brexit can look very different. However, no aviation company should leave these effects unchecked. There is very little time left. And if you now want to know more about European or global politics, YouTube has chosen another of my videos right here for you in the end screen, right next to your way to subscribe to my channel, and I really appreciate if you do. I'll see you in my next video. Click and enjoy. Viel Spaß!